Now this is CPL Article 260 and it's jury trials generally. 1. CPL 260-30. True or false? The jury must render a verdict. False. The jury must retire to deliberate to a place outside the courtroom and, if possible, render a verdict. 1. CPL 260-30. True or false? The jury must render a verdict. False. The jury must retire to deliberate to a place outside the courtroom and, if possible, render a verdict. 2. True or false? The jury deliberates in the courtroom. False. The jury must retire to deliberate to a place outside the courtroom. There's usually, we have a jury room in the back. 3. The people may or must deliver an opening address to the jury. And the answer is must. The people must deliver an opening address to the jury. 4. The people must offer evidence in support of the indictment. 5. The people and defendant may or must deliver a summation to the jury, and that is a may. The people and the defendant may deliver a summation to the jury. 6. Generally, a defendant may waive a jury trial except where the charge is murder in the first degree, and that is true. In a trial of an indictment, a trial cannot proceed unless the defendant is present, and that is false. If a defendant conducts himself in a disorderly and disruptive manner such that the trial cannot be carried on with him in the courtroom, he may be removed from the courtroom if, now remember this, he has been warned by the court that he will be removed if he continues such conduct. He then continues such conduct and he doesn't stop, then he can be removed after that. If a defendant is disruptive in a courtroom, he may be removed and the trial shall continue. And that is false because it's the same thing as the last question. He has to be warned. That's what it's saying. He has to be warned. If he doesn't stop, he's going to get kicked out. And if he continues, and then he gets kicked out. This is correct. The jury must deliberate in a place outside the courtroom. In a trial of an indictment, a defendant may waive a jury trial except where the charge is murder in the first degree. In a jury trial, the jury must be selected and sworn. The court must deliver preliminary instructions to the jury. The people must deliver an opening address to the jury. And the defendant may deliver an opening address to the jury. Number 4, in a jury trial, people must offer evidence in support of an indictment. Defendant may offer evidence in his defense. And the may offer advice in rebuttal. And the defendant may deliver a summation to the jury. Number 5, which of the following statements is false? At the conclusion of evidence, the defendant... Oh, I'm just doing this. I'm not doing false. I'm just doing if it's true. At the conclusion of evidence, the defendant may deliver a summation to the jury. People may deliver a summation to the jury. The court must then deliver a charge to the jury. And the jury must retire and deliberate and, if possible, render a verdict. Okay. Now we're on CPL 270, which is jury trial formation and conduct of jury. In a trial of an indictment, each side has the following peremptory challenges. An A felony, it's 20 for regular jurors, 2 for each alternate. For B or C felony, it's 15 for regular jurors, 2 for each alternate. And for a D felony, it's 10 for regular jurors, 2 for each alternate. Why does that have that? Wait a minute. In a criminal case, when 2 or more defendants are tried jointly, the number of peremptory challenges remained the same, right? Yes. The maximum number of alternate jurors in the trial of an indictment is, as directed by the court, but not more than 6. If the trial jury has begun its deliberations and one of the jurors cannot continue, yes. If the trial jury has begun its deliberations and one of the jurors cannot continue, I got this wrong on the last test that I took, so now I remember it. The court may replace the juror if the defendant consents, and that's it. 6. Which of the following relating to a jury viewing of premises is correct? How is Mary so good at this? I don't understand. Okay. Which of the following relating to a jury viewing of premises is correct? A. Jury must be kept together throughout. B. Jury must be under the supervision of an appropriate public servant appointed by the court. D. The court must be present throughout. C. Prosecutor, defendant, and counsel may, as a matter of right, be present. And that's it. Okay. Now we have jury trial, motion for a mistrial. Do all the questions for 270? No, I didn't. Back to 270. In a trial of an indictment, a peremptory challenge must be allowed if the majority of defendants join in the challenge. True. In a trial of an indictment, a peremptory challenge must be allowed if the majority of defendants join in the challenge. It's not if one defendant just says, oh, I want to use a peremptory challenge on this one. If they're having a joint trial, they have to agree to it. When a jury views a premises, the defendant must be present. And that's false. He may be present, or she, whatever. 7. A challenge to the entire panel of jurors may be made only by the defendant. A challenge to the entire panel of jurors may be made only by the defendant. Who has the opportunity to use their peremptory challenges first? The people or the defendant? Oh, the people. I was going to say, like, have I been doing everything wrong this whole time? Who has the opportunity to use their peremptory challenge first? The people. 10. Number of peremptory challenges where the highest crime charged is a felony is 20 peremptory challenges for each side. For each side. 9. Number of peremptory challenges where the charge is a D felony is 10 for each side. I forgot that it was each side, and I was just doing one side, and I didn't get the question right, because I was only looking at one side and not the other. And, yeah. So just remember it's for each side. And that's it. Recording. So I just made a whole video thinking I was recording it, and I wasn't. So this is CPL Article 300. 1. Consecutive counts are 2 or more counts upon which consecutive sentences may be imposed. 2. At the conclusion of the summations, the court must deliver a charge to the jury. 3. Types of counts where guilty of the offense charged in one necessarily negates guilt of the offense charged in the other are known as inconsistent counts. 4. Concurrent counts are 2 or more counts upon which concurrent sentences may be imposed. 5. Every count not submitted to the jury is deemed to have been dismissed by the court. 6. Verdict of guilty to a lesser included offense is deemed an acquittal of every greater offense submitted. Consecutive counts are 2 or more counts upon which consecutive sentences may be imposed. Concurrent counts are 2 or more counts upon which concurrent sentences may be imposed. 3. Inconsistent counts are counts where the offense charged in one necessarily negates guilt of the offense charged in the other. And inclusory, I am so tired. Inclusory concurrent counts, lesser included offense, are when the offense charged in one is greater than those charged in the others, and when the latter are all lesser offenses included within the greater. Inclusory concurrent counts, lesser included offense, are when the offense charged in one is greater than those charged in the others, and when the latter are all lesser offenses included within the greater. Does anybody fucking understand that? Oh, God. Why are my kids still awake? Okay, so there's inclusory concurrent counts. This is when the offense charged in one is greater than those charged in the other, and when the latter are all lesser offenses included within the greater. So what this means is, like, sometimes you'll see people, being that I work in arraignment sometimes, charged with criminal possession of a controlled substance in the third degree, which is a B felony, and criminal sale of a controlled substance in the third degree, which is a B felony. But then they'll also have 5 counts of criminal possession of controlled substance in the seventh degree, which is an A misdemeanor. Now, all those criminal possessions in the seventh are all lesser included within the indictment, because those are the lesser included counts, and the greater one are the felonies. So that all happened within the same transaction. They just, because of the weight and the types of drugs that they have, they were charged as misdemeanors, and the other ones were charged as felonies. Okay, this is CPL 300, jury trial, court's charge, and instructions to a jury. Now, consecutive counts are 2 or more counts upon which consecutive sentence may be imposed. 2. At the conclusion of the summations, the court may deliver a charge to the jury. False. At the conclusion of the summations, the court must deliver a charge to the jury. 3. Types of counts where guilty of the offense charged in one necessarily negates guilty of the offense charged in the other are known as inconsistent counts. 4. Concurrent counts are 2 or more counts upon which concurrent sentences may be imposed. 5. Every count not submitted to the jury is deemed to have been dismissed by the court. I'm losing my mind. Okay. This is allowable pleas for juvenile offenders, and if it's 14 or 15 years old and it's murder in the second degree, the allowable plea may be any crime to which the defendant is criminally responsible. If it's any crime other than murder in the second degree, it's any crime to which the defendant is criminally responsible, unless the plea of guilty is accepted as per the one above. Any crime other than murder in the second degree, the DA may recommend removal to the family court. Such plea shall be deemed to be a JD fact determination. Removal to the family court shall be as per CPL 725. Okay, and that's it. CPL Article 380. Sentencing in general. Article 380. Number 1, the court must pronounce sentence on each count. 2. If defendant is being sentenced on a felony, the victim may request to speak. Requests must be made at least 10 days before the sentencing date. Requests must be made at least 10 days before the sentencing date. The court must notify the defendant of a request at least 7 days before the sentencing date. The court must notify the defendant of a request at least 7 days before the sentencing date. 3. If the defendant is in custody after conviction of a violent felony offense, the DA must if the defendant is in custody after conviction of a violent felony offense, the DA must, within 60 days of the sentence, provide the victim with a form on which the victim may indicate a demand to be informed of the defendant's escape, discharge, parole, conditional release, release to post-release supervision, transfer to the custody of the Office of Mental Health, or release from confinement. Violent felony offense, the DA must, within 60 days of the sentence, provide the victim with a form on which the victim may indicate a demand to be informed of the defendant's escape, discharge, parole, conditional release, release to post-release supervision, transfer to the custody of the Office of Mental Health, or release from confinement. 4. When a person is convicted of any of specified crimes, the specified crimes are a violent felony in Penal Law 70.02, 2, felony in Article 125, which is homicide, vehicular manslaughter, and manslaughter, murder, and abortion. 3, felony in the Penal Law 130, which are sex offenses. 4, a felony in Article 255, which is incest. 5, 263, which is a sex offense. 6, 135, which is a sex offense, and 130.25, which is rape in the third degree. 7, 230.05, sex offense, 230.06, sex offense, 230.30, and 230.32, sex offense. Such form shall be maintained by the prosecutor. So all those offenses are included. When a person is convicted of those crimes, the DA must, within 60 days of sentence, provide the victim of those crimes with a form which may indicate a demand to be informed of any petition to change the name of the defendant. Any petition to change the name of the defendant. So that's what it's for. Upon receipt of notice of application to change name, prosecutor must promptly notify. Again, the prosecutor must promptly notify the victim at the current address of where, the time and place the petition will be presented to the court. 5. The court may not sentence the defendant at the time conviction is entered, and that is false. The court may sentence the defendant at the time that conviction is entered if pre-sentence report or fingerprint report is not required, or if required has been received. And they're supposed to be received 1 day prior, and in family court on a juvenile defendant, it's 5 days prior. And they're supposed to be received 1 day prior, and in family court, a juvenile defendant, it's 5 days prior. Okay, so pre-sentence report in the CPL criminal is 1 day before, and in juvenile delinquency, it's 5 days. I remember that. 6, if after the court sets the date for pronouncing sentence, it decides to have a pre-sentence proceeding, notice of such a proceeding automatically adjourns the date for pronouncing sentence. And that is true. If after the court sets the date for pronouncing sentence, it decides to have a pre-sentence proceeding, notice of such a proceeding automatically adjourns the date for pronouncing sentence. 7. Except where the defendant is a corporation, the defendant must always be present at the time sentence is pronounced. False, false, false. That is false. Okay? The court may sentence the defendant at the time that the conviction is entered. Oops. Whatever. Number 7 is still false. For misdemeanor or petty offense, the court may, upon motion of the defendant, dispense with the requirement that the defendant be present. Okay, so for a misdemeanor or petty offense, the court may, upon motion of the defendant, require that the defendant not be present. 8, in general, the document that serves as the authority for the execution of sentence and serves as the order of conviction is the certificate of conviction. So again, that one is the document that serves as the authority for execution of sentence. So again, document, execution of sentence, and serves as the order of conviction is the certificate of conviction. 9, when there is an indeterminate or determinate sentence, a certified copy of minutes of sentence must be delivered to the person in charge of the institution within 30 days from the date the sentence was imposed. And 10, upon judgment of conviction, which, what is a judgment of conviction? That is the conviction and sentence. Okay, so upon judgment of conviction for assault and other listed misdemeanors, again, what are they? There's an other listed misdemeanors in the book. I have no idea. Upon judgment of conviction for assault and other listed misdemeanors, which are not in the notes that I have, the clerk of the court shall send a copy of written determination to DCJS to enable DCJS to report determination to the FBI to identify persons prohibited from purchasing and possessing firearms. Purchasing and possessing firearms. Okay. So more questions. 1, when person is under 19, I remember that, Okay, when a person under 19 who is enrolled in elementary or secondary school is sentenced for a crime, sentencing court shall notify the designated educational official. Such notification shall be for the purpose of the student's educational plan and shall not be part of the permanent record and shall be destroyed at the time the student is no longer enrolled in the school district. If youthful offender, no notification is needed. 2. The court may sentence the defendant at the time of conviction. The court may sentence the defendant at the time of conviction where any such report is required. The report has been received. 3. With reference to sentencing, in general, the defendant must be present at time sentence is pronounced, and sentence may be pronounced against the corporation in absence of counsel. So that's good to know because it says that they always need counsel. So here it's saying that sentencing may be pronounced against the corporation in the absence of counsel. So that's the only time I've ever seen where they can do anything without an attorney for a corporation. Where am I? 4. The authority for the execution of a sentence is the certificate of conviction. Let's see. Yay! The authority for the execution of a sentence is the certificate of conviction. And 5. Where an indeterminate reformatory or alternative local reformatory, what the hell? I can't even pronounce half these words. Sentence is imposed. A certified copy of minutes of sentence proceedings must be delivered to the institution within 30 days from the date the sentence was imposed. And that's all I have for 380.